Okay, so welcome to our now fourth panel of Friday, the 6th of December. This is one of our our key sort of speak attractions in terms of panels. I personally have been looking forward to this panel for so many reasons. The first one is that it is taking place at Arnold Porter, uh, to which we are immensely grateful. It is one of our sponsors, but also close to my heart because I was I know for an associate at the beginning, then an associate, then a senior associate here at Arnold Porter. So it is very important and close to my heart to be here, and with this former colleagues and be in this premises, as I sort of speak was educated here. My only law firm, big law firm. So thank you for for what you have contributed in my upbringing, and in so many ways, especially investor state arbitration, drafting, oral skills, etc., and business. Well, now the other reason is this is a panel that brings two worlds together: the world of business and human rights, and the world of international arbitration. And when we refer to business and human rights, there's many experts. There's even a world association of which Extragy, our law firm, is part of, and that focuses on namely, I would say, business and human rights from a very sort of corporate perspective, not necessarily dispute settlement of disputes that involve human rights or even international arbitration matters. And then the other world is international commercial arbitration and investor arbitration. How how can these two be brought together is the question. Uh, Washington Arbitration Week and its sister event, the World Arbitration Update, which happens in May every year in various jurisdictions, has always included a panel on business and human rights and international arbitration. That's one of our hallmarks because we believe that those two worlds need to be brought together. And perhaps a year ago, we started to talk with Katia Smol, and part of the question was how to make this right, how to bring these two worlds together, where international investment arbitration and international commercial arbitration understand the world of business and human rights and take that into account. I won't steal anybody's thunder, but where there have been very minor and shy um, attempts to bring them together in some investor arbitration decisions. But our belief, at our law firm, is that there should be more. There should be more because at the end of the day, some of the applicable law for investor arbitration, special treaty arbitration, is international law. And as some tribunals have said it, well, if international law is the applicable law, and if part of international law is human rights, well, perhaps some investment treaty tribunals may have jurisdiction to hear some of those cases. Um, so I'll leave it at that. And now would like to introduce Katia very shortly. Uh, Katia Yanaka Smol brings 3 decades of experience in major public international organizations and the private sector, spanning public international law, international investment policy, law and arbitration, commercial arbitration, anti-corruption, ESG, and business and human rights. She has experience advising states and states entities in the negotiation of major international agreements, finding common ground and solutions, and representing them in high-stake disputes. Before private practice, Ms. Yanaka Smol had a long and distinguished career in major international organizations, in particular at the OECD. She founded and led its analytical work on international investment agreements and arbitration since the early 2000s and initiated a dialogue among OECD and non-OECD governments, practitioners, academics, and civil society that led to common understanding and concrete improvements in the investors' state dispute settlement system. The result of her work, published by the OECD, have been widely cited as pioneer work in this field. She was a leading expert in the groundbreaking OECD work on anti-corruption and led this work up to negotiation of the OECD Anti-Bribery Convention. Most importantly for our panel, I think that she is someone that brings experience to bridge those two worlds, international arbitration and the world of human rights and business. So with that, Katia, welcome and you have the floor.
Thank you, Jose Antonio. And thank you all for being here. I would like to welcome you to Arnold Porter. We are happy to be among the sponsors of the Washington Arbitration Week, and would like to thank the organizers for including us and also congratulate them for a very successful week full of excellent, thought-provoking events. We have the privilege to be closing this week with two panels, the one now on business and human rights in commercial and investment arbitration, and the second following this one on arbitration and climate change. A cocktail will follow to reward you after a full week of events, and also for being so brave to stay with us on a Friday afternoon. On this panel, I'm honored to be surrounded by esteemed colleagues and friends, Janet Whitaker, Shireen Foti, Doug Cassel, and Carlos Bernal. Doug and Carlos will join us remotely. Now, business and human rights, for those who are not familiar with the field, concern the obligations on companies out of quest for corporate accountability to mitigate or prevent the adverse impacts of business activities on individuals and communities. Although the main responsibility, a duty to respect human rights, lies with the state, which legislates and enforces relevant laws, since the adoption of the UN Guiding Principles on Business and Human Rights in 2011, there is a responsibility emerging for businesses to have policies and processes in place to identify their impacts and mitigate them. Other instruments, such as the OECD guidelines for multinational enterprises, follow this approach. The soft law approach has been hardening the last few years, with national laws being adopted and a recently adopted EU directive. Now, what we will explore on this panel is how business and human rights related issues arise in international arbitration, both commercial and investment. We will look into the current challenges faced by participants in arbitration in addressing human rights issues. How have arbitral tribunals dealt with these issues? What are the tools that can be used to enhance the consideration of human rights in international arbitration? We'll also discuss the new generation investment agreements emerging with relevant language, a set of arbitration rules, the Hague Rules on Business and Human Rights, specifically designed to deal with this issue, the role of other forms of dispute settlements, such as mediation of the OECD national contact points, for instance. And we conclude with some ideas for the future. There will be no formal presentations, but we'll have a discussion. Any questions you may have, you can address them to us at the end of the session. But before we start, I will briefly introduce my co-panelists to you alphabetically. Carlos Bernal, who is joining us remotely, is a professor of constitutional law and torts at the University of Dayton in Ohio. He was previously a sitting justice on the Colombian Constitutional Court. In 2021, he was elected as an Inter-American Human Rights Commissioner for the term 2022 to 2026. Professor Bernal also holds a fractional appointment as professor of law at the University of La Sabana in Bogota, and he has previously held academic positions at Macquarie Law School in Sydney, Australia, and the Faculty of Law of the University Externado of Colombia. His work has been published in prominent journals, as well as books and edited collections in several languages. Doug Cassel, who is also joining us remotely, is a globally recognized expert on business and human rights and criminal law, and public international law. He advises and represents corporate, governmental, and non-governmental clients in matters before the Inter-American Commission and Court of Human Rights, United Nations human rights bodies, the International Criminal Court, national contact points under the OECD guidelines, national courts, international arbitrations, the ICJ, the International Tribunal for the Law of the Sea, and in international treaty negotiations. He's counsel with King & Spalding and co-chairs the Business and Human Rights Lawyers Association. He was a tenured full professor at Notre Dame Law School and has taught in several schools around the world and published extensively. Shireen Foti, who is here with us, is an associate with Covington in Washington, D.C. She advises clients on a broad array of complex international commercial and investor state arbitrations and non-judicial disputes relating to issues of ESG, business and human rights, and corporate social responsibility. She's a duly qualified common law and civil law lawyer. Shireen is an adjunct professor of international arbitration at the George Washington University Law School and previously taught at the Sorbonne and Assas Law Schools in Paris. Janet Whitaker is a senior counsel with Clifford Chance in Washington, D.C., specializing in complex international arbitration and litigation. She has handled international commercial investment treaty arbitrations held under the auspices of several arbitral institutions on a broad range of industries. Janet has an active pro bono practice representing clients in matters involving international human rights law, including business and human rights. Previously, Janet was legal counsel at ICSID, has been a lecturer in international arbitration at Stanford Law School, and taught European law at University College London. She also sits as an arbitrator. So to start our session, now we will start with the stage setting, so we understand what this interaction between business and human rights and international arbitration is. And I will address the question to Shireen and Janet. How do human rights related issues are presented in international arbitration? In which sectors do we see a great number of disputes involving these issues? I will turn to Shireen to give us case scenarios and answer this question related to commercial arbitration.
Thank you so much, Katia, and thank you for having us here today. I'll be very brief on this first point, just to do a bit of stage setting. Commercial contracts are increasingly incorporating elements of ESG into their provisions. So as ESG is becoming increasingly prevalent, we're seeing that spillover into the commercial world through the incorporation of various contractual provisions related to ESG. So increasing ESG clauses, increasing ESG obligations on the parts of different parties involved in commercial relationships. And such clauses can include provisions such as setting net zero targets as those become increasingly relevant to various industries, protecting human rights, labor rights, or the environment in supply chains or in business relationships, incorporating governance requirements such as anti-bribery, corruption, or money laundering, which sometimes can touch upon issues of human rights, and mandating the use of specific types of, for instance, packaging, shipping, or labor requirements in the production of goods. So as companies are faced with the obligation to increasingly conduct human rights due diligence in their operations and in their supply chains, we're seeing those obligations simultaneously be incorporated into contracts as commercial entities seek to mitigate as much as possible, or pass off risk and define the risk at the outset, and try to consider where risk should lie in their commercial relationships. So we're seeing that appear increasingly in commercial contracts, and I can give some further examples as we continue. So of course, with arbitration provisions, as we have arbitration clauses in some of these contracts, the substantive ESG provisions then become relevant in this.
Thank you, Shireen. Now I will turn to Janet to give us the case scenarios in investment arbitration. Janet.
Thanks, Katia. So human rights have always been part of the international legal landscape in which investors and states operate. So they're definitely not new bedfellows. And I'll give you a few examples. So 4 examples of the ways in which human rights have played out or been presented in investor-state claims. The first one is where you have a claim by an investor against a host state for either a human rights violation as part of a breach of a standard of treatment under a treaty, or as a separate human rights claim. If we all think about it a little bit, human rights are actually inherent in certain investment protections. I think they're inherent whether because of they're sort of inherent in something like expropriation, you're taking somebody's property rights away, or under customary international law. And I think one good example here is denial of justice. That's a customary international law concept, but it also forms part of fair and equitable treatment. And that protection is found in most investment treaties. And that particular protection can encompass human rights such as the right to a fair trial, the right to equal treatment, and the right to be heard. So a good example here is the Lowen case, which many of you will be familiar with, which involved a claim for denial of justice under Chapter 11 of NAFTA. In that case, an investor had brought a claim following for a manifest denial of justice following a massive judgment made against that entity in state court in the United States after a jury trial. And the investor was unable to appeal that decision, which it felt was very unfair because of this exorbitant bond requirement. And the claim there was a breach of denial of justice, but inherently in that there is a lack of an access to a fair trial. That's the underlying obligation, or the underlying claim. The second situation where we've seen human rights being raised in ISDS is where you have host state defenses to investor claims about measures impacting an investment. And I think here, essentially what is happening, states are saying that here is the reason I took this regulatory measure. It was actually based on these public interests around human rights. I think a good example here is Zurich against Argentina. In that case, the claimant claimed that Argentina had interfered with the tariff regime that was applicable to the claimant's investment. It was a water concession in Argentina. And it claimed that the state's failure to increase tariffs was an indirect expropriation and a breach of other obligations under the treaty. And Argentina actually raised as a defense that it had actually taken these measures based on the right to water. So essentially couldn't raise the tariff because of the right to water, and this would have been impeded had it raised the tariffs. So what we see there is this conflict, and in fact, Argentina raised it specifically between this public human right and the private right of the investor. In that case, the tribunal actually found that it wasn't a human rights consideration that had led to the failure to increase the tariff, but actually it was more political. So that's the second instant, a host state defense. The third one is where you have a counterclaim by a state that the investor itself violated human rights protections. And we'll get into this a little bit more detail later, but the best sort of, I think the key case in this area is again, a case that also involves an investor bringing a claim against Argentina in relation to a water and sewerage concession, and it's Urbasa. And in that case, Argentina actually specifically counterclaimed against the investor and said that it had failed to respect the right to water by not investing sufficiently in the infrastructure to ensure that its operations were successful. And it's an important case because it's really the first case where the tribunal decided that it was competent to actually determine the counterclaim, and it determined that on the basis that it was sufficiently connected to the underlying claim. But on the human rights front, what the tribunal said is that ISDS is not only for the benefit of private investors, but actually that the human rights are relevant to both investors and to states. And so that there are obligations on all parties, public and private, not to engage in activities that infringe on human rights. And then briefly, the fourth place where we've seen human rights coming up in ISDS is in amicus curiae briefs. And so in many, many briefs, in many cases, we've seen amicus curiae or amici curiae relying on human rights, including the right to water, the right to health, labor rights, in order to assert their arguments. And we've also seen the limitation of these arguments. I think that we've seen limitations, especially in cases where they're grounded in human rights specifically, rather than on the investment treaty itself. And also you have limitations where the amici curiae are raising human rights arguments in cases where the parties themselves are not raising those arguments. So, you know, I know that one of the other things that you mentioned before, Katia, wanted to talk about was how human rights are present in investment agreements. But I wanted to turn over to Shireen for that.
Yeah, actually, we will get into this a bit later. Now, what I would like to ask is, what are the current challenges that are faced by participants in arbitration addressing human rights issues? How have arbitral tribunals dealt with these issues? Have they do they do enough to address them? And I will turn to Doug to give us his first take on this.
Thank you, Katia. The short answer is that arbitral tribunals, by and large, have not, in my judgment, taken adequate account of human rights in their arbitral decisions, either from the perspective of human rights or from the perspective of what would be possible under international law. There are a few decisions, particularly the Tulip Real Estate annulment decision of 2015 and the Orbasser decision that Janet mentioned a moment ago of 2016, where the tribunals have recognized that international investment law is not a world unto itself. It is part of international law. It should be considered in the context of other international treaties and principles to which states parties to investment treaties are bound. And so the two should be read together. That can be done. It has been done, but only in a handful of instances has it been decisive. There have been many mentions of human rights in all the categories that Janet just mentioned, but usually they are mentions that lead nowhere. So there's a lot of room for improvement in this area. And in part, I think it frankly reflects the reality that most members of arbitral tribunals come from a commercial law background. They're experts in commercial law and related issues, but very few of them are experts or have strong backgrounds in international human rights law. You can see that particularly by contrasting some of the opinions of Philippe Sands, who sits as an arbitrator but is also a human rights expert, with the opinions of others on the tribunals where he has been a member and on other tribunals where he was not a member. So partly what we need, I think, is education. And if we don't get there, it may be a disservice not only to the people who are affected by international investments, sometimes adversely, but also to the whole international, the ISDS, Investor State Dispute Settlement Regime, which peaked, frankly, in the middle years of the 2010s, roughly from 2013 to 2017. We averaged something like 80 to 90 new investment arbitrations initiated each year. In the last few years, that's dropped by about a third. You can see similar numbers in the statistics for the number of new international investment treaties being adopted. Those two peaked in 2019 and have fallen considerably since then. So if the ISDS regime is to continue serving its purposes, I should say, many of which are important, more attention, in my judgment, needs to be paid to the context of these treaties in broader international law, including human rights. And of course, that also includes, looking ahead to your next panel, the human right to a clean, healthy, and sustainable environment.
Thank you, Doug. I think Janet may have some comments as well on this.
I think it's really important to, this sort of falls into the broader context, I think, that Doug is mentioning, which is this sort of tension or perceived tension between public considerations, so considerations around human rights, around climate change, how we actually accommodate some of these really important public prerogatives in a world that is really, in a way, privately or historically has been viewed as privately centered. And I think that we will, as Doug, I fully agree with what Doug said, which is that we will continue to see these tensions. I think probably we see a lot more pushback, and we'll continue, particularly in this country, to see pushback over the coming years on various grounds against investment arbitration. But it also, I think, it makes it very important for the arbitration community to think about the claims that are being made about why ISDS or arbitration generally is incompatible with all of these other really important prerogatives, and not just to think about how they actually sit comfortably, like how can we help them to sit comfortably together, but also to ensure that these other developments are being reflected in this area of practice. So fully, I very much agree with what Doug said.
Does anybody else, Shireen or Carlos, have any comments on this?
Very briefly, I just say that it is increasingly becoming not an option to ignore human rights issues. So to the extent they're being implemented, especially at the regional level in Europe and also in various jurisdictions, for example, I think of California in the US, or other jurisdictions in Asia who have adopted particular human rights or ESG focused regulation. Companies, this is no longer kind of an aspirational corporate social responsibility type obligation that companies should strive to achieve and to implement. It's now becoming increasingly binding and hardening, as others mentioned earlier. So I think tribunals need to follow suit and be familiar with these mechanisms and these frameworks in order to be able to address the pressing commercial issues of today. And the reality of that is that companies are confronted with these issues daily, and they need to completely adapt their frameworks in order to come into compliance to the extent that they're in scope of these regulations.
Yep.
Katia, following up on that,
Yeah.
I was speaking earlier of investor state arbitration. Shireen spoke previously about commercial arbitration and has just added a point there. I think relevant to that is that under many of these new emerging hard norms, companies are required to engage in human rights due diligence with respect to their supply chains. and to take actions to try to promote human rights in their supply chains, including by contractual provisions. And the American Bar Association has a set of model contract provisions for business and human rights, which would include provisions for international arbitration, commercial arbitration between a company and its suppliers in the event of disputes. And there's a developing set of model contract provisions being developed by a group of people in the European Union as well, that likewise will have provisions, or at least currently has provisions for international arbitration for dispute resolution. So I think we're going to see more and more of that in the future in the field of commercial arbitration as well.
Yeah,
If I can,
yes, Carlos, yes.
thank you so much, Katia, and I would like to say hello to my fellow panelists and to everyone there in Washington, D.C. Also, thank you to Jose Antonio for the kind invitation to participate in this panel. I just want to say 3 points. The first one is that I totally agree to Doug and Janet and Sharon in the sense that people, that arbitrators, they need to take into account deeply the matters concerning human rights. But, and this is my second point, being a human rights commissioner, I can tell you with knowledge about that also people working in the area of human rights need to be aware of the implications of all the cases concerning the protection of the rights of investors. For instance, at the Commission, I have been pushing to the hosting of a hearing concerning this breach between investors' protection and human rights. So also my colleagues can get this alphabetization concerning what to expect in terms of protecting the rights of investors and how not to be not to be absolutist in the sense that only human rights matter. So I celebrate this panel because in this panel I see that we are creating a bridge between two worlds that are traditionally separated, also in forums and jurisdictions. And then my final point is that the reality is that many of the investors that are operating in many countries, and let me use a couple of examples from Latin America, they operate in a market that is heavily regulated, and human rights, and also in the form of constitutional rights, they belong to that regulation. And in this sense, the state has also duties concerning the respect of those human and constitutional rights, and also domestic competitors, they are under those duties. So the investors should be treated equally to the domestic investors. And if we have to create that equality, also the foreign investors, they need to comply to the human rights obligations in the same way as the domestic companies they must do. So on the basis of the principle of equality, it's also necessary to establish that connection between protection of investors on the one hand and human rights on the other. Thank you so much.
Thank you, Carlos. Janet, you want to add something, or we move on?
We can, I'll bring it up later.
Yeah, you bring it up later. Okay. So there are efforts which we'll discuss. I mean, there are new investment agreements with language that includes issues of human rights, respect of human rights, etc., which we'll develop a little later. But what I would like to touch upon is today. What are the tools we have today without this, with the old generation of investment agreements that do not include specific language? And we are faced with issues related to human rights. What are the tools that exist today to take action in this field? So I turn to Janet to give us some reflections on this issue in the context of investment arbitration.
So Jose Antonio in the introduction mentioned something really important, which is sort of the applicable issues around applicable law. And I think one of the really difficult issues, particularly in ISDS, is to what degree arbitral tribunals can take into account a state's human rights obligations as they consider claims. And that we've had cases where tribunals have taken the approach of not considering individual human rights claims, but actually then incorporating human rights considerations in the same case into a claim under the treaty. But it's a really important question, and it's inevitable. I think we're going to see very different approaches across different cases, depending on the terms of the applicable law provision in the underlying treaties, and also potentially the terms of the human rights treaties to which the relevant states have adhered. So if you have a provision that's very broad that says you take into account the international law obligations to which the parties have subscribed, well, some states, I'll take the UN Convention for the Rights of the Child, for example, the US has not ratified that treaty. So therefore that treaty is not relevant in the context of US obligations, but yet it's relevant in the context of human rights obligations for almost every other state on the planet. So there will be differences. And I think one of the things I wanted to mention here is that there's a real potential for this to generate criticism about inconsistent treatment of human rights. But one of the tools that I'm going to just mention briefly, which many people here will know about, is that can be used by tribunals to resolve this issue, is the principle of systemic integration. So international investment law and ISDS don't sit in a vacuum. Multiple areas of international law touch on both investment law, but also investment disputes. And the one that we're talking about today is obviously human rights law. And one of the questions that arises is how the tribunals that are constituted under these investment treaties, and they're subject to the boundaries of the parties' consent, how they actually accommodate and address claims that bring in different fields of public international law. And the principle that's been employed here is this principle of systemic integration, and it's founded on Article 31.3c of the Vienna Convention, the laws of the treaty, laws of treaties. And it's really a rule of treaty interpretation. And what that provision says is there should be taken into account, together with the context, any relevant rules of international law applicable in the relations between the parties. So really what this principle does is it tells tribunals, when you are interpreting treaties, you're not limited to the express terms of those treaties, but you have to place them in the context of other relevant rules of international law that are applicable in the relations between the relevant state parties. And presumably these rules include international human rights law. So it's really an interpretative mechanism, and it allows both international law and tribunals to accommodate these competing priorities. And so in a case involving human rights, it potentially enables a tribunal to take into account human rights obligations when it's assessing claims. I think that we could have an entire session talking about systemic integration and the intersection of different parts of international law, including law relating to climate, with international investment law. So I'll leave it there. But I think there is still, systemic integration is a potentially really useful tool, but I don't think it necessarily answers the question when claims are raised that fall outside the terms of a treaty claim. So it doesn't necessarily help us to resolve pure human rights claims made in the context of an investment arbitration. So just throwing it out there, it's a very helpful interpretive mechanism. It will doubtless become more important, I think, across the whole field of international law as we navigate these competing priorities, but there will still be a lot of questions out there about how it applies and what happens, particularly in the investment treaty context, where you're relying on a treaty when something totally outside of that treaty is brought in to a particular dispute.
Yes,
It's a
that-
challenge, Janet, because it requires the arbitrator and the lawyers to know something about both fields of law. And often they're great experts in one, but not the other. So it's difficult, and it suggests to all of us that we need to learn a lot about international law and not just stay in our particular wheelhouses of specialties. And the second thing is that as you correctly stated, it's not really ruling on a treaty outside the treaty that the arbitrators have jurisdiction to interpret. It's interpreting the treaty over which they have jurisdiction. It's a recognized interpretive tool. So it's by no means an illegitimate bringing into the arbitration a treaty that doesn't belong there. It's simply one that is an interpretive tool of the treaty that is at the center of the dispute.
Also,
and
if
yes,
I can
sorry.
say something about that, the whole point or the main problem concerning this systematic interpretation is at the end, we just have collisions, and sometimes arbitrators they don't have a clear methodology on how to solve those collisions. I think, for instance, concerning some cases related to Colombia, in which even the Constitutional Court had many issues trying to solve collisions between the right of the investors and the right of the companies that invested in a project in wetlands. They invested like $800 billion in a project, and then suddenly they discovered that this was polluting the water that a whole city was using as a primary source. So the point is here the state has two kinds of obligations. On the one hand, the obligation to honor the protection of the investors, but on the other hand, the obligation to respect the right to water to the people. So the whole problem of systematic interpretation is how to solve that collision, and sometimes this is not clear. So it is. I totally agree with you that systematic interpretation is necessary in the sense that we should take into account all the factors, but at the end, what we have is a big collision, and arbitrators they need to navigate that collision. Thank you.
Shireen, I mean, there is another way, another tool. Would you like to talk to us about it?
Sure, I'm happy to speak about the incorporation of human rights mechanisms into existing treaties by reference. So while ESG as a term or human rights as a term may not be expressly referenced all the time, you may have instances in which certain mechanisms are incorporated into treaties by reference, whether that's in the preamble, in substantive provisions, or other defenses that are raised in treaties. So you see this increasingly in some of the newer generation bilateral investment treaties or multilateral investment treaties, which are purporting to seek a balance between, on the one hand, promoting and encouraging investments, and on the other hand, ensuring that such investment is responsible and contributes to sustainable economic development. So these provisions can provide for the promotion of investment, but in a manner that it doesn't come at the expense of detraction or diminishment of human rights, or beyond human rights, environmental standards, labor rights, etc. And so they established the promotion of these international standards that state parties, and in some instances investors, depending on how they're drafted, should strive to comply with. but they also deliberately exclude certain investments which contravene those objectives. For example, they can provide carve-outs for things like human rights violations. They can protect legitimate public interests, like the right of the state to regulate around human rights issues. And some of those policy objectives that you might see increasingly in this new generation are things like corporate social responsibility, that terminology, but which is now, you know, increasingly broadened and hardening in nature. Preventing human rights violations, protecting labor rights, striving for gender equality, protecting indigenous rights. Those are things that we're increasingly seeing. And so there's three main ways in which this is done in the treaties. First, you see this incorporation by reference to other multilateral instruments on human rights. So you might see a reference to the OECD guidelines on responsible business conduct that were mentioned earlier. You might see a reference to the UN guiding principles on business and human rights, or the Sustainable Development Principles. In relation not to human rights, but to climate change, you might see references to the Paris Agreement, for instance. And you know, many provisions are actually incorporated in the preambular language in a manner that makes reference to internationally recognized standards, including and then listing, you know, the relevant mechanisms or instruments. So just by way of example, for example, the Canada Model BIT of 2021 refers to internationally recognized standards, guidelines, and principles of responsible business conduct. And then it lists, for example, the OECD guidelines, and it lists the UN guiding principles on business and human rights. Other treaties incorporate different provisions, and some incorporate those as well. So that's one way. And then secondly, you have these express human rights related provisions, substantive provisions. You have provisions on corporate social responsibility, so obligations, for example, of investors to comply with host state domestic law around human rights. Acknowledgement of encouraging incorporation of internationally recognized standards on human rights. And in some limited cases, such as in the case of the Dutch BIT, Dutch model BIT, you have even potential liability, civil liability, right, of investors in their home state for acts and decisions which could lead to significant damage, personal injury, or loss of life in the host state. So this, of course, could encompass human rights questions. And then lastly, I mentioned at the outset two specific sets of carve-outs. So denial of benefits, right? So failure to extend benefits of protection of the human rights, of the investment mechanisms, of the treaty mechanisms. So clauses, denial of benefit clauses, and then secondly, legitimate public interests, which expressly allow states to regulate around questions of human rights. So you can see these in some newer model treaties. For example, the Colombian model BIT has a very extensive denial of benefits clause, which includes committing serious human rights violations. So if if an investor commits a serious human rights violation, then they cannot benefit from certain treaty. There's also things like causing serious environmental damage or participating in terrorist activity or violating the host state's labor law. And then lastly, legitimate public interest. You can see many of the new generation model BITs allowing states to regulate within their territories with respect to human rights. So you see, for instance, in the Dutch model BIT, you see a reference to, not the Dutch, the Colombian model BIT, a reference to legitimate policy objectives of human rights, health, public order, labor rights, the environment, etc. I'll stop there in the interest of time.
Yeah, thank you, Shireen. Doug, there are also some other issues, other ways of dealing with those issues. For instance, in terms of contributory fault or reduction of damages. You have something to say on this?
Sure. Some tribunals in the past have dealt with human rights almost without using the word and without using any of the techniques we've mentioned so far. So for example, in Copper Mesa versus Ecuador, which I think was a 2014 award, if I recall correctly. In that case, the Canadian company investor was accused of having committed unlawful acts of violence against villagers who themselves had perhaps committed some unlawful acts, but the company had committed unlawful acts of violence in the course of trying to clear the way for its mining project. And the tribunal, without importing any human rights treaties or using systemic integration, employed the doctrine of contributory negligence and said that the company was at least negligent. The tribunal preferred to treat it as a case of negligence rather than intentional commission of wrongs, at least by the Canadian headquarters. And as a result, it found the claimant was responsible for 30% of the damage that it would otherwise have been awarded, and reduced the damages accordingly. A similar but different approach was taken by the tribunal in Bear Creek versus Peru, where the majority of the tribunal held that the consultation that had been done with local stakeholders, indigenous groups, was not sufficient. But rather than rule that that was a violation of human rights, which could have been its ruling, instead, it took the view that regardless of any action taken by the state, the company's failure to ensure adequate consultation with the local community, or the state's failure to do so, meant that there was never going to be social license for the plant, or excuse me, for the mine. And as a result, the company could not get recovery of its claim for the future stream of profits that would have been generated by the mine. And the company was instead awarded only its sunk costs for the monies spent up to that point. And the end result of that was a huge reduction in the amount of the damages claimed compared to the damages actually awarded. And there are other examples, but these are two examples of how tribunals, without expressly invoking human rights treaties, have taken human rights into account at the phase of, in effect, damages. But this is likely to happen or to be done only in really egregious cases. And both of those were pretty egregious on the facts.
Thank you, Doug. And another tool we mentioned, Janet mentioned this in the beginning briefly, is counterclaims. Would you like to just elaborate a little more on this?
Sure. I mentioned earlier that human rights sort of come up in multiple contexts, including where states actually use human rights obligations, both in the context of defenses when claims are brought against them, but also to bring counterclaims. Just a couple of things about this. I think on the counterclaim front, well, number one, using human rights in a defensive or counterclaim capacity is actually quite rare still. So it's not a tool that is yet very developed. Obviously, it's got potential, but just we should keep in mind it doesn't and hasn't happened very often. There is a question around counterclaims, different schools of thoughts about whether and what circumstances they can actually be progressed. I won't go into that here, but there are certainly some sort of procedural questions around counterclaims. I think one of the interesting points that we have to keep in mind, both in relation to defenses and counterclaims, is that it can be against the state's interest in certain circumstances to raise human rights issues, because states themselves can be held liable for human rights violations relating to investors. So the Aguasini case against Nicaragua, where there was a logging concession and the state itself was held responsible at the Inter-American Court on Human Rights for allowing that concession to move forward. So, states sometimes will have to conduct a really delicate balancing act to decide whether it really is in their interest to raise human rights when there is the specter of claims against the state in another context, whether domestically or perhaps in a regional human rights court, for those claims to come back and actually impact it in another context.
I'd only like to comment on that, that it's true that tension arises in many cases, but not all. There are certainly some cases where states have clean hands in regard to human rights, but a claimant might not.
Carlos, since you are, we have the privilege of having you here with the experience you had as a member of the Constitutional Court. What is the role of constitutional courts, regional courts, and commissions in reviewing human rights issues and treaties? We're talking about treaties, including language or not including language on human rights. If you could bring us your experience in this.
Thank you so much, Katia. And I will be very brief for the sake of time. First, I think courts, they are playing an important role when they have a say in the process of ratification of international treaties, and in particular, BITs. For instance, one of the jobs that I did when I was a justice at the Colombia Constitutional Court was to draft the decision 252 of 2019, which is a leading case. We had the privilege to have Jose Antonio as one of our experts in the hearing down there in Bogota. And one of the things that the court did at the time was to make sure that the treaty, that was the treaty between Colombia and France, that treaty comply with the Constitution. And when we talk about the Constitution, it's not only about the organic part of the Constitution, that is to say, the powers of the president, etc., but also constitutional rights with our human rights transformed. So that is one point that is becoming more popular, in particular in Latin America. Then the second possibility for constitutional courts to try to address this issue is when they receive petitioners, like in the form of constitutional complaints, the so-called amparo or tutela, or the Verfassungsbeschwerde in Germany, in which people claim that their constitutional rights have been violated by a party, which usually is a company, and that company is protected by investors' rights. So my point here is that also constitutional courts, they should be educated in international investment law, so they take that into equation, not only from the point of view of constitutional rights, but also from the point of view of the respect of the rights of the investors. And then the other point, which is completely different, is concerning the regional commissions of human rights and also the courts. As I mentioned before, I am a commissioner since January 2022, and every session of hearings, I push for a hearing, or at least a panel with experts concerning the protection of investors. Why is that? Because what I see is too many radical people that claim we don't care about them. The only thing we care is the environment or the rights of indigenous peoples, or just for being mining in the whole country, something like that. And they forget that without investment, it is impossible to have a welfare state, public education, public health in some of the countries in Latin America. So that's what must come in the future years, is that institutions like the Inter-American Human Rights Commission or the African Human Rights Commission, they open their ears to the protection of the investors, always with the sake or with the aim of strike a balance of taking into account all the points of view and try to make a commitment in the middle. Thank you so much.
Thank you, Carlos. Basically, we just need to get out of our silos and try to bridge the different, fields together. There are some tools that we have today in the field of commercial arbitration, Shireen, and also there are other mechanisms outside the arbitration that give access, conditional access to protections on human rights compliance. If you could just say a few words about this.
Yeah,
Thank you.
absolutely. Thank you. So Doug mentioned earlier this question of commercial contracts and particular model clauses which deal with human rights or ESG issues more generally. So for example, the American Bar Association has a model set of contract clauses which provide for a clause to be incorporated into a commercial contract, a clause which imposes mutual obligations on buyers and sellers, if it's that kind of commercial relationship, with respect to combating certain abusive practices in supply chains or in other business relationships through human rights due diligence mechanisms. So for instance, I'll just read you one of these clauses so you get a flavor of what we're talking about here. So this is the ABA Model Contract Clause 2.0, clause number 1.1a, which states that buyer and supplier each covenants to establish and maintain a human rights due diligence process. So there we're talking about, the internal processes of companies to establish human rights due diligence risk identification mechanisms. Appropriate to its size. So there we're talking about, the scale of these internal, internal mechanisms and circumstances to identify, prevent, mitigate, and account for how each a buyer and supplier addresses the impacts of its assessment of its activities, on the human rights of individuals directly or indirectly affected by their supply chains, consistent with the UN Guiding Principles on Business and Human Rights. So there, again, we have the incorporation by reference of the framework of the UN GPs, the UN Guiding Principles on Business and Human Rights. And we have the reference to that due diligence framework. Maybe some of the audience members might not be familiar with it, but kind of this three-pronged mechanism whereby companies are obligated to identify, mitigate, and prevent, and mitigate human rights impacts within their supply chains, or now kind of even extended further to their business relationships. And there's some debate going on as to whether that incorporates financial investors, for instance, or other types of kind of business actors beyond simply the supply chain relationships. And I'll just finish the rest of the clause, which states that such human rights due diligence shall be consistent with guidance from the OECD for the applicable party's sector, or if no such sector-specific guidance exists, it should be consistent with the OECD due diligence guidance for responsible business conduct. Those are mechanisms that provide some sort of interpretation as to how the OECD guidelines should be interpreted and applied to particular industries. So there's one, for instance, for footwear and apparel. There's another one for mining, the mining sector. Each kind of major industry has, well, I shouldn't say each, but many of the major industries have this guidance to show how precisely they should take these questions into account. So, clauses like this can be quite useful in bringing commercial parties' attention to these issues if they've not already been exposed to them. And they may also, pass risk to the extent that is, part of the negotiation, and the companies seek to do that. I'll just, should I speak about the OECD, the NCPs now, or maybe?
Yes, you have, yes.
Okay, very
yes,
briefly.
yes.
So, of course, we're talking in the framework of international arbitration, but there are, of course, a whole host of non-judicial dispute resolution mechanisms. And one of those, and we're very fortunate to have Katia here, who participated in creating these mechanisms, the OECD National Contact Point Framework. And essentially, each OECD member has a national contact point which evaluates complaints that are brought against companies with respect to their compliance with the OECD guidelines. And of course, this incorporates some aspects of human rights due diligence, but it also is broader in that it has environmental claims, labor claims, other possible claims. There's an initial admissibility phase to determine whether a complaint is appropriately situated within the context and there's appropriate standing on the issue. And then the parties can seek some sort of amicable resolution, oftentimes through mediation, as a way of finding some sort of remedy to address the relevant situation. And the remedies are wide-ranging. You may have a request for compensation, but you may have something completely different, such as a request to modify a process or procedure internally, or a request to issue a public statement or recognize some sort of past harm. They can be quite creative, and of course, reputational risk is going to be a real component of relevance to companies' assessment as to whether they participate in this non-binding mechanism or whether they, view it as something that's impactful upon their business relationships. And lastly, I'll just mention, the OECD framework is one, but there are many other complaints frameworks, non-judicial complaints frameworks, such as through the various UN special rapporteurs and working groups, as well as national human rights institutions. So various countries have their own human rights institutions that can also hear claims. And of course, the European regulatory framework sometimes incorporates or touches upon some of these mechanisms.
Thank you. Anybody has anything to add on the OECD procedures?
Yes,
National counterpoint instances? Doug, I think you have some experience with those.
I do. Studies have indicated that they are by and large ineffective. They have produced very few concrete results on the ground. If you compare them to international arbitration awards, which are enforceable under the New York Convention, the reality of the NCP process is incomparably smaller than what we're talking about when we deal with international arbitration, where if a human rights issue is raised, whether it's a counterclaim or a defense or a reduction of damages, it can result in real meaningful impact. Whereas the NCP process, while well-intended, because of the lack of political will by OECD member states, they were not willing to give it enough teeth to make it work in practice. So it's a good thing to be there. In my experience, many companies, when I explain what it is, say, well, we're just going to boycott it. There's no point in our playing ball with that process. So sorry to be the skunk at the garden party on that one.
Could I add just one responsive comment? I would argue that, perhaps there are no binding kind of teeth, as you know, Doug, but I would argue that there can be a significant impact of these types of cases upon company internal processes, especially with this kind of creativity of remedies that might be available. And I think the reputational factor is not one to be discounted, especially nowadays where companies are increasingly adopting kind of commitments towards making progress on many of these issues, including human rights. Many, especially the very forward-looking industry leaders, do not want to be associated with a complaint that says that they're engaged in, somewhere in their supply chain, they're engaged in human rights violations. So I would argue that although it's not decisive and not binding, it can have a significant reputational risk, perhaps when paired with all of the other mechanisms existing at the international and regional level to exert pressure for companies to conduct their industries in a compliant
Yeah, good arguments. My point is not so much that it isn't binding as that it has not achieved results.
Fair point.
So there's a lot to be done to strengthen them, strengthen the mechanism, I think,
Right.
because it's has a very good basis, and it just needs to be strengthened, taken more seriously, and be actually advertised more broadly. I
Right.
think that is an issue. Now we are running out of time. I think we're close to our, but I would like to just briefly mention the specific set of rules actually that has been created, adopted for this particular issues, the Hague rules on business and human rights, which are arbitration rules. So just briefly, why they have not been used. So your take on this before we conclude.
Well, first of all, they haven't been used. They were adopted 4 years ago. There has not been a single use of them. Some of us during the comment period argued to the drafters they were unlikely to be used. And the reasons why they were unlikely to be used, I think, are the reasons they have not been used. There are a number of reasons, but just to mention two, what is the incentive for either party to use those rules? There are disadvantages to both parties. Number two, who's going to cover and how are they going to cover the costs of arbitration, which can be quite significant for the poor communities, assuming that it is a poor community, or individuals whose human rights have allegedly been harmed. Now, maybe with some of these developments that Shireen mentioned earlier, we may actually see some use of these rules, particularly in a business-to-business context. That's probably the most likely, or alternatively, if a state requires by regulation that the rules be used, that's possible in the future, but it hasn't happened yet.
Any quick comment on this?
I just, obviously the lack of experience makes it difficult to tell, but to Doug's point, I think it's although lots of procedural innovations have taken place in relation to the Hague rules, it's still very unclear whether it's workable for the populations who would most in a victim to business dispute, whether actually it's accessible at all, and whether it's because they're the people who are most poorly equipped to actually use arbitration for lack of awareness, cost, etc. So whether it's still workable. But if there are business-to-business disputes, it is possible that the victims will actually benefit. So a corollary sort of side effect of those will be that victims benefit, because one of the purposes of the rules, generally, not the arbitration rules, but the underlying principles on business and human rights, is that the priority should be to remedy those who have suffered the adverse human rights impact. So I think the hope is that even in the context of business-to-business disputes, there are positive effects for individuals and communities who have been impacted.
Now, wrapping up, I would like each of you to give us in 30 seconds or as briefly as possible, your take on looking forward. What is your expectation about whether human rights issue will feature more frequently or more prominently in international arbitration? And what does it mean in practice for international arbitration practitioners, party representatives, experts, and arbitrators, for instance? Janet.
I can jump in on that. I think it's inevitable that human rights considerations are going to become more relevant. Both, the rebalancing of this new generation of investment treaties, I think we'll continue to see that grow. Also, just this more general recognition that business activities give rise to human rights impacts. The fact that certain to date responsibilities under the UNGP are now in some jurisdictions being translated into actual obligations. that is pushing towards human rights becoming more relevant in business operations. Also with climate change, so human rights are actually the main instrument through which climate change claims are prosecuted. And we will see clarity around the interaction of different areas of law, perhaps not investment law, but certainly human rights law, international law generally, the international climate regime, international environmental law. We're going to see some clarity coming out of, for example, the ICJ, the Inter-American Court of Human Rights. Those sort of advisory opinions will, I think, provide more substance for parties to rely on in these in investment cases. So I think we'll also see investors knowing more at the stage of investment and being seen to know more. So there's going to be an obligation on investors to take into account things like climate obligations. I think states will ultimately claim more freedom to regulate on human rights, in particular climate grounds. But I still think that the system has a long way to go before it's really calibrated to handle these claims in a way that really takes into account human rights considerations, because ultimately it's still an investment regime. And just on the practical side of this, on the investor side, there is an opportunity for everyone to learn about these other areas of law that are going to become more relevant, and particularly in investor state cases and climate related cases, we're all going to need to know about human rights. And just on the commercial side, I think that when we do see business to business disputes that come out of supply chain issues, so where there's adverse business impacts because of activity in a supply chain, that it's going to be really challenging for arbitrators, because rules like the European directive, the Corporate Sustainability Due Diligence Directive, don't just imagine parties walking away. So there's no, you won't simply be able to say you breached the dispute, therefore here's the compensation. There are all kinds of steps that have to happen. So you're really thinking about impacts on the people who are adversely impacted, how you actually try and help the supply chain to survive. And I think that that will be a challenge for all of us, but also an opportunity to look at things through a different lens.
Thank you, Janet. Carlos.
Very short. First, international arbitration panels and international commercial panels must take into account human rights obligations by states. Second, the investors as such must take into account human rights standards, domestic, regional, and international. And third, domestic courts must learn and to take into account international arbitration's obligations of the states. And finally, international human rights bodies must take into account also the fact that the states have international obligations concerning the protection of the rights of investors. Thank you so much.
Thank you, Carlos. Shireen.
I would agree with everything that's been said thus far. I would just add a couple of points. Number one, they're going to be, as we're seeing currently in the United States, conflicting regimes, where here you're having an intense anti-ESG sentiment followed by regulation and, for example, state attorney generals and financial controllers' action against companies for their efforts around sustainability, DEI, and we can envisage human rights being the next big topic as well. That would contrast very expressly with what's happening in Europe and in other jurisdictions. So I think that fragmentation and the danger and the companies needing to follow suit and have region specific strategies for addressing those is going to be really central to how we're seeing that arise in the disputes context. I would also say that as states are obliged to come into compliance with regulatory instruments, both regional, international, and domestic, there's going to be an increasing tension between the right to regulate and the respect of investor rights under the treaty framework. So the framework needs to adapt in a way that is going to be able to reconcile those two sets of rights in a manner that allows states to comply, for example, with the Paris Agreement or with the Corporate Sustainability Due Diligence Directive, but in a way that's also protective of investor rights. So I think those tensions are really going to be what is inherent in the next phase, but it's inevitable that we need to take into account human rights in that assessment.
Thank you, Shireen. Doug, the final word before we take some questions.
I agree with everything that's been said. I'd just like to point out a structural defect of siloism, if I can call it that, both in the investment regime and in the regional human rights regime. In the regional human rights regime, the Inter-American Court has recently decided or is about to decide cases that impact very severely the rights of companies, the investment rights of companies, certainly their interests. And yet those companies have no party standing, either before the Inter-American Commission or the Inter-American Court. The most they can do is file amicus briefs. Likewise, in investment arbitrations these days, affected communities whose human rights may be adversely affected have no party standing. They have to rely on sort of third-party benefits as a corollary, as Janet said, from a business to business or a business to state dispute. In my view, both of those situations are structural defects in the mechanisms of international law. The real parties of interest are at least threefold in each of those situations, and yet the actual formal parties with procedural rights are only two. In the long run, it seems to me we need to address both of those problems, and I'm encouraged to hear that Commissioner Bernal is raising it in the inter-American context, and I hope some of his fellow commissioners pay attention.
Thank you, Doug. Now, I would like to ask you if any of you has any questions. Yes. Let's see, there was an issue with the micros before. Yes, there is. There is none here.
Can you hear me? Yes, you can. Well, thank you. Yeah, well, here's one. For this one?
Yeah.
Now you can hear me. Oh, yes. Thank you, Katia, very much for your for moderating this. I have, and thank you, Doug, for your last comment, because we now have the topic for next year's human rights and business and international arbitration panel, which will be, I can announce it already, the lack of standing of companies before the Inter-American human rights system versus the lack of standing of certain communities before investment tribunals. I think that is a key topic, and happy to announce it. But beyond that, what I would like to ask, which is one of our battle horses in human rights and international arbitration, are your views, and I know we've discussed this before, Doug. You might not be embracing the following, but I would like to hear the opinions of especially Janet and the others on trying to make the investor state arbitration system a more balanced one with regard to especially those communities that could be affected by investment projects and by some of the investments that take place in the territories of states. Part of the, at least in my view, part of the issue of the reason why direct claims by states and also counterclaims by states if anything, might be heard by tribunals in terms of violations of human rights, but like in Urbasser, might just go that far, but not make it to the merits in a victorious way, is because when you read I would dare saying 98% of the investment treaties, there are no obligations for investors concerning human rights. There are soft obligations, like in the Canada, Colombia FTA. There are hortatory provisions, but there are no hard law obligations in most treaties. There's a handful of treaties that do that, but most of them they don't. So some of the proposals that we have put together, including for some parliaments in Latin America, from our pro bono practice at Strategy, is to provide provisions or model provisions whereby states or treaties would include binding obligations for investors within the treaty. Not You cannot include the whole local law within a treaty, neither directly nor by reference, but something to the effect of certain minimum customary standards related to labor, um, environment, and human rights. So I would like to hear your views on that type of proposals. When you ask counsel in investor arbitration, who mostly represent investors, they say, well, that's what local law is for. But then um, if there are violations to that extent, and if the investor leaves the country, good luck trying to enforce any arbitration award against the investor. So I know that it's complex, but I would love to hear your views.
I can, on the point about bringing these considerations and interests into investment arbitration, you identified the issue, which is that very few treaties specifically reference them. And obviously, the move that's being made towards incorporating human rights and broader corporate social responsibility considerations into treaties will go a long way towards addressing that specifically. I think there have also been important efforts by institutions and in relation to certain arbitral rules to increase transparency, to allow third parties to participate, or at least to be able to understand what's happening in proceedings and to make their voices heard, whether directly in proceedings or outside of those, which I think gives them more legitimacy. So I think all of this will be slow moving. We'll have this shift in the treaties. There'll be the procedural avenues for at least presenting positions. And then tools like systemic interpretation will become more relevant. But I think when we think about the existing tools like systemic interpretation, one thing I would say that's really important is that decisions by tribunals on these issues are principled. They need to be really robust. They need to be thoughtful, well thought through, and take into account and to understand the intersecting obligations, including human rights, which aren't intuitive to everyone who does arbitration. It's a new field. So there really is, I think, I come back to this opportunity to really understand these areas of law that are going to butt heads and cross increasingly. But it will be a slow and piecemeal process while we are moving towards an entirely new generation of treaties, if that happens. I'm not saying it will happen because there's, not every state will want to do that, but there will at least be a push by some states to incorporate these principles. So I don't have any solutions, but I do feel as though things will happen. And one of the really important things is that it's done in a very principled way by people who understand the issues.
If I may on this, the negotiation of new investment treaties include obligations of investors. I mean, that is a long-term, let's say, solution. And let's not forget the treaties as purpose. These treaties have the protection of investors. So we have to find something, different type of treaties in order to include all these responsibilities. But investors do have responsibilities, and they are existing instruments today that are soft law, the UNGPs, OECD guidelines, they're hardening. There are more and more companies that have to undergo due diligence. They have to adopt due diligence mechanisms. And it's very hard to say now for a knowledgeable tribunal to look at an investor and say he didn't know anything about it and he was not supposed to be responsible. So I think there may be ways of dealing with these issues when they arise in an investment arbitration, in addition to systemic integration, that could be used by a tribunal, by a knowledgeable tribunal today, before we look into how a new investment treaty in like 10 years will take care of it. So in a more practical way, let's say, just my take.
We've seen that play out already. For example, in Bear Creek, where you had the majority opinion and the dissenting opinion, where there was a dispute as to whose obligation was it to engage in the community consultation process, right? And was it the state that had to set up the mechanisms for the protection of that establishment of that, or was it the investor's obligation? And so I think many of these issues, before we get to, as Katia was noting, to the actual implementation of these new generation BITs, we may see them start to play out in these types of disputes of attribution of responsibility for particular established obligations.
Anybody else?
Yeah, maybe if I can say something is that look here. The point is the fragmentation. How to bridge again the gap between these two regimes. And then one possibility is, of course, what all of you have suggested, namely to incorporate human rights treaties in the framework of the investment treaties. But the other possibility is from the point of view of human rights, is that, look, if there is a company that is violating all the human rights in a country, and then that country, for instance, it happens to be a country that belongs to the Inter-American system, and that country requests a hearing in which the whole purpose is to denounce those violations, I can tell you that this is going to be more impactful that counterclaim from the state, in the sense that how much is going to be the value of a stock of a company that has been publicly accused with evidence in a hearing of the Inter-American Human Rights Commission as a company that has violated human rights. So there are many angles to this, and of course there can also be abuse on the side of human rights. But changing the treaties is not the only possible ways to bridge the two worlds. Thank you so much.
Thank you. Any other questions? Okay, I would like to thank our panel for this very rich conversation on this issue. And thank you all for staying with us.